Hello, I'm Molly, a licensed insolvency practitioner at Parker Walsh. And in this video, I'm going to be looking into whether or not you can set up another limited company if you've closed your existing one. So I'd always recommend that you speak to your licensed insolvency practitioner that you've instructed to deal with the existing company, whether they're the liquidator or administrator, whatever role they're in, they'll be able to advise you specifically in regards to your case as to whether or not you could set up another limited company. But if we just look at it in general terms, so let's assume the company enters into a creditors voluntary liquidation, a very common type of liquidation. Can you set up another limited company straight away? Yes, you can. So essentially, you're not disqualified as a director, so there's no restrictions in that regard. And then assuming there's no bankruptcy order in regards to this, then yes, you can set up again. So you're not automatically banned the minute you put a company into liquidation. You can set up again within a few seconds. It's absolutely fine. There are some restrictions and some things that you just need to be careful of. One is the company name. So you would have to use a different style of branding or a different type of name because there's restrictions on the director for using a similar sounding name, and that applies to your limited company, to your trading name, etc. So just make sure that you abide by that and trade under something completely different. Then if you're doing something similar to the company that's, say, gone into liquidation, make sure that you've got the right to use whatever assets of that company that you've taken over. So if it was, say, a hairdresser's, for example, and it's gone into liquidation and you've set up again, well, you would need to buy the tables, the sinks, the chairs. There's the physical assets, and similarly, if you were a retailer, you would need to buy the stock. So make sure in regards to the physical assets, the tangible assets, the ones that you can touch, that you've actually purchased them and for fair value. And then you have a right to use those in the new company. But you also think about the intangible assets. So they're assets that you can't touch. So goodwill, using the emails, the website, the contact list, contracts, etc. Those sort of things. So make sure that you have a right to use them. Again, discuss it with your insolvency practitioner, and it might be that that's the best thing for creditors anyway, for you to set up again, because you might be buying something that no one else particularly wants, so you bring in much needed money into the liquidation estate. So just to conclude, you need to act carefully and you do need to discuss it with your insolvency practitioner. But yes, you are not automatically disqualified and you cannot set it again. You can do. You just need to be careful in regards to the name of the business and what assets you're using. If it's a members voluntary liquidation, a solvent liquidation, I suggest that you speak to your accountant and they'll be able to advise on the tax implications. Okay, thank you.